Hello friends, welcome to our class. Now we are going to start a special provinces for some states. The Article 371 to 371J in the Part 21 contains the special provinces for the 12 statewide. The meet the aspirations of the backward region of the states are to promote the culture and economic interest of the tribal people or to deal with the disturbed law and order. Originally, the constitution did not make the special provinces for these states. They have been im- incorporated by the various subsequent amendments. Article 71 371 Special provinces with respect to the state of the Maharashtra and Gujarat. Article 71A 371A The special provinces with the respect to the state of Nagaland. Article 371B The special provision with respect to the state of Assam. Article 371A C a special provision with respect to the state of Manipur. Article 371D. The special provision with respect to the state of Andhra and state of Telangana. Article 371E. A special establishment of the Central University in Andhra Pradesh. Article 371F a special provision with respect to a state of Sikkim. Article 371G a special provision with respect to the state of Mizoram. Article 371H a special provision with respect to the state of Arunachal Pradesh. Article 371I a special provision with respect to a state of the Goa. Article 371J a special provision with respect to the state of the Karnataka. State Legislature. Article 168 to Article 212. The composition of the state legislature varies by state, depending on whether the state has the unicameral or bicameral system. Unicameral legislature, legislative assembly, Vidhan Sabha. Most Indian states have a single legislative house and the legislative assembly. The bicameral legislature. Some states have the two houses. Legislative Assembly Vidhan Sabha Lower House, Legislative Council Vidhan Parishad Upper House. The six states have the Legislative Council Andhra Pradesh, Telangana, Karnataka, Maharashtra, Bihar, Uttar Pradesh. Legislative Assembly Vidhan Sabha composition. Members are the directly elected by the people of the state through the direct election. The strength varies based on the state's population, with a minimum of the 60 member and a maximum of the 500 member as per the Article 170. In the case of the Arunachal Pradesh, Sikkim, Goa, minimum number is the fixed at 30 and some members of the legislative assemblies in the Sikkim and the Nagaland are also elected indirectly. Term. The members serve a 5-year term unless the assembly is dissolved earlier by the governor. during the national emergency in the term can be the extend, but after the revocation, the assembly should be the re-elected with the 6 month. Note: 87th Amendment Act of the 2003 provide for the delimitation of the constitution on the basis of the 2001 census and the not 2091 not 1991 census. However, it can this can be done without altering the total number of the state in the assembly of the each state. Legislative Council Vidhan Parishad. The composition and the election method for Legislative Council are the defined under the Article 171. The composition and the membership, the size. The the Legislative Council membership cannot exceed one third of the Legislative Assembly's membership and must be at least four 14 member. The strength, the actual strength fixed by the Parliament. Term, members of the Legislative Council serve for the 6 years with one third uh, retiring every 2 years. The creation of the council shall not be the deemed as the amendment under the Article 368. The election of the members. The members of the Legislative Council are elected by the system of the proportional representation by the means of the single transferable vote. Backward background is as follows. One third are the elected by the member of the Legislative Assembly. One third are the elected by the local bodies such as the municipalities and the districts board. One twelfth are the elected by the teachers of the least of the 3 years and the standing in the state. One twelfth are the elected by the graduate residing in the state. Re- Remaining members are the nominated by the governor from the individual with a special knowledge or the practical experience in the areas such as the literature, science, art, competitive movement, and or the social services. Legislative Assembly Vidhan Sabha and the Legislative Council Vidhan Parishad. Aspects: Legislative Assembly Vidhan Sabha, Legislative Council Vidhan Parishad. Composition: Legislative Assembly varies by the state population, minimum 6 and maximum 500. System of the election: Legislative Assembly directly elected by the people of the state. Duration: 5 years unless the dissolved earlier. Qualification to be a member: must be the citizen of India, minimum age 25 years, and the meet the state specific qualification. Must be a electoral or for assembly constituency in the concerned state. Representation of the People Act 1951. Legislative Council Vidhan Parishad. Composition: size limited to the one third of the Legislative Assembly, minimum 40 members. System of the election: Legislative Council indirectly elected by the various groups, MLAs, local bodies, teachers, graduates, with some members nominated by the governor. Duration: 6 terms with one third of the members retiring every 2 years. Qualification to be a member: must be a citizen of India, minimum age 30 years, and the meet the state specific qualification. Must be a electoral for a assembly constituency in the concerned state and to be the qualified for a governor's nomination. He must be a resident in the concerned state. Qualification. Vidhan Sabha qualification. As per the Article 191 and the 192 reason, include the holding an office of the profit unsound mind under change and the insolvent or not the being a Indian citizen. Vidhan Parishad. Some disqualification criteria as the Legislative Assembly. The provision of the proof the representation of the people 1951 regarding the disqualification to be the MPs also be applies to the legislators seat parliament chapter. The vacation of the seat, the double membership if the person is elected to both houses and his seat is a one of the houses falls the vacant as and the various of the law made by the state legislature. The disqualification. If a member of the state legislature becomes subject to any of the disqualification, his seat becomes the vacant. The resignation. Writing the chairmen of the legislative council or speaker legislative assembly. Absence. A house of the state legislature can be declared the seat of the members vacant if he absent himself from the all its meeting for a period of the 60 days without its preparation permission. Other cases, if the election is declared void by the court, if he is expelled by the house, if he is elected to the office of the president or the office of the vice president, and if he is appointed to the office of governor of a state. Presiding officer, the speaker, legislative assembly, elected by the assembly members, vacate if the case he be it be a member of resign, the two deputy speaker or removed. Duties: maintains order, interpret the constitution and rules, decides the money bill status and the handles the disqualification case, the casting votes used in the ties, the committee, appointed committee chaired by the supervisors, and the speaker of the legislative assembly shall vacate his or her office his or her office if he or her cases to be a member of the assembly. He is removed by the resolution passed by the majority of the all then the member of the assembly. Such a resolution can be the moved only after the giving 40 days advances notice. Deputy Speaker, Legislative Assembly, elected by the Assembly after the Speaker, vacate under the similar condition as the Speaker, duty act as a Speaker when the absent, with all the power of the Speaker, panel of the Chairman nominated by the Speaker to presides in the absence. Chairman Legislative Council, the elected by the Council member, vacate if the case to be a member resign the deputy chairman or the remove the duty similar to the speakers but the lack of the authority over the money bill salary fixed by the legislature. Deputy chairman legislative council elected by the council member vacate if the case to be a member of the resign or removed the duties act as the chairman in their the absence with the full power. The panel of the vice chairman nominated by the presides and the needed. Legislative procedure in the state legislature. Type of the bill in the state legislature. The ordinary bill cover the general subject not related to the finance. Money bill deal with the taxation, state funds or the public expenditure and can only be introduced in the legislative assembly. The financial bill related to the revenue and the expenditure but are not the classified as the money bill. Stages of the Stages of the passing an ordinary bill. Introduced in the first reading. If a bill introduced in the Legislative Assembly or the Legislative Council in bicameral state, the Speaker or the Chairman of the Council decided if the bill can be introduced. The bill is the read out but no discussion occur at the stage. Second reading consideration stage. The bill is undergoes the detailed scrutiny and is debate. It may be the referred to the selected committee or the joint committee if the applicable for a detailed examination. The committee submits its report and the bill is discussed the clause by the clause. Third reading passes. The final debate on the bill takes the place primarily or the overall principle. The member vote on the bill. If the passed by the majority, the proceeds of the other house in the bicameral. Consideration by the other house if bicameral. If the Legislative Assembly passes a bill, it moves to the Legislative Council where it follows the some stage. The Council can approve the bill is without amendment, reject the bill assembly or repass the after the 6 month. The suggest the amendment assembly can be accept or reject them. Withhold the bill or the 3 month, reduce the 1 month if the introduced. Therefore, the ultimate power of passing the ordinary bill vested in the assembly at the most of the council can detail the delay in the bill of the period of the 4 month, 3 month in the first instance and 1 month the second instance. Now, moreover, when the bill which the originated in the council and was sent to assembly is rejected by the assembly, the bill is in and becomes the dead. The passing a money bill. The money bill can only be introduced in the Legislative Assembly with the prior recommendation of a governor. After the passage of Assembly, the bill goes to the Legislative Council which can only make the recommendation. The Assembly can accept or reject the Council recommendation. If the Council does not return the bill within 40 days, it is the deemed passage in the original form. The governor may either give his assent, withhold his assent, and reserve the bill and the presidential assent, but can't return the bill and the consideration of the state legislative when a money bill is reserved for the consideration of the president. The president may give his assent or withhold his the assent, but can't return the bill of the consideration of the state legislature. Governor uh, assents, assents. Governor's assents. Once both houses, it applicable, passes the bill, it sent to the governor for approval. The governor can give assent and making it a law. Withhold assent. Return the bill except money bill or reconsideration. If the governor return the bill for reconsideration and if the bill is passed by the house or the both houses again with the withhold the amendment and the presented to the governor for his assent. The governor must give his assent to be the bill. Thus the governors enjoy only a suspensive veto. The reserve the bill for the president's consideration, particularly if the conflicts with the joint law or the affect the union interest. The bill reserved for the president. If the bill is reserved for the president consideration, the presidents can give the asset making if the law, the withhold the asset. The direct governor to be returned the bill is the state legislature with specific amendments for the reconsideration. When the bill is returned, the house of the house or the house have to be reconsidered it within the period of the 6 month. The bill is presented again the presidential asset after the pass by the house or houses with withhold the amendment. It is not mentioned in the constitution whether the obligatory or on the part of the president to give his assent to the such a bill or not. There is no provision of joint sitting in the state legislature. Session of the Legislative Assembly. Definition. The period during which the state assembly meets or conduct its the businesses. Type of the session. The budget session February to May. Most important focus on the budget discussion. The monsoon session, July to August. Usually the follow the budget session. The winter session, November to December. Shortest session, mainly the legislative work. The minimum requirement. The constitution mandates that there must be at least 2 sessions per year, with the maximum gap of the 6 months between the two sessions. Key term. The term description. Summon, summon, summon. The governor summon each houses of parliament. The session start after the governor summons. Notice is the given a few weeks in the advance. The adjournment. The break in the daily houses proceedings announced by the presiding officer, speaker of the chairman, can be for a few hours, day, week, but within the some session. The house resumes on the specified date. The adjournment sine and die. Latin word adjournment without assigning a day. The house is adjourned identically with no date set up the resumption. The called by the presiding officer and often happen near the end of a session. Prorogation. The formal termination of the session by the governor, usually after the house of the adjourned sine and die. All pending houses except bill lapses, but the uh, un- unfinished bill and the committee work and continue to the next session. The conduct under the governor's authority passed by the governor's advice. Dissolution. The appeals only to be the Vidhan Sabha, not the Vidhan Parishad, which is a permanent body. The ends of the tenure of the current Vidhan Sabha either by the automatic dissolution, completion with the 5 year term, the premature dissolution done by the president on the prime minister advice. The all businesses pending in the Vidhan Sabha, including the bill, lapses with the dissolution requiring the reintroduce in the next Vidhan Sabha. The position with respect to the lapsing of the bills and the dissolution of the assembly is: a bill is pending in the assembly lapses whether the originating in the assembly or transmitted to it by the council. A bill lapsed by the assembly but the pending in the council of lapses. A bill pending in the council but not passed by the assembly does not lapses. A bill passed by the assembly in the bicameral state or passed by the both houses in the bicameral state but pending asset the governor or the president does not lapse. A bill passed by the assembly in the unicameral state or passed by the both houses in bicameral state but returned by the president and the reconsideration of the houses does not lapse. The camp- comparisons of the legislative procedure. Introduction of the bill. The parliament, a bill can be introduced in either Lok Sabha or the Rajya Sabha and can be introduced by the minister or the private member. The state legislature, similarly, a bill can be introduced in either legislative assembly or legislative council by a minister or the private member. The process through the both houses. The Parliament bill passes through the three readings in this originating house. After each them must be agreed upon the both houses either with the withhold the amendments. The state legislature. The same process applies in the state legislature when the bill passes through the three reading in the originating house of the require agreement from the both houses. The deadlock resolution. The parliament deadlock occurs in the second houses reject the bill proposes the amendment not acceptable to the first house or does not passes the bill within the 6 months. The constitution provides for a joint sitting of the both houses to resolve such deadlock. State legislature. A similar deadlock can be occur in the state legislature if the legislative council reject the bill is proposes unacceptable amendments. However, there is no provision for the joint sitting. Instead, if the Legislative Assembly passes the bill a second time after the rejection by the Council, a bill is deemed to passes by the both houses. The override mechanism. The parliament, the Lok Sabha can't override the Rajya Sabha by the passing a bill is the second time. A joint sitting is required to the resolve any deadlock. The state legislature. The legislative council can be override the legislative council by passing the bill of the second time. If the legislative council rejects the bill or the fails to pass it within the month and the council is deemed to passed by the both houses. Uh, Concluding points. The parliament deadlocks between the house are resolved via the joint sitting which apply to the both houses can be applied. A bill as the originating in the either houses. The state legislature. The override mechanism in the state legislature applies only when a bill originates in the legislative assembly and the deadlock can be resolved by the passing the bill. For the second time, the assembly no provision for the joint sitting. The procedure regarding the money bill are to the same in the parliament and the state legislature. The position of the Legislative Council. The constitutional position of the Legislative Council (LC) as a comparison to the Legislative Assembly (LA) can be the analyzed to term of areas where they are either equal or unequal, equal to the Assembly. The power of Legislative Council are the broadly equal of those of the Assembly in the following areas. Ordinarily bill. The both houses can be introduced and the passes ordinarily bill. However, in the case of the disagreement with of the assembly prevails, the ordinances. The legislative council must approve the ordinances issued by the governor. Selection of the minister. Minister, including the chief minister, can be a member either a house, but they remain accountable to the assembly. The reports of the constitutional bodies. The legislative council consider report for the bodies like the state finance commission, state public service commission, and the control and auditor general. The state public service commission and the legislative council have the role of expanding the jurisdiction of the state public service commission, the unequal to the assembly. In the following area, the legislative council has a fewer uh, powers than the Assembly. The Money Bill. The Money Bill can only be introduced in the Assembly and the Legislative Council can't amend or reject them. It must return them with recommendation with 40 days. The power of the Money Bill, the Assembly has the final say the accepting or rejecting the Legislative Council's recommendation on the Money Bill. The final decision on the money bill, the Speaker of the Assembly has the final authority to determining if the bill is a money bill. Ordinary bill. While the Legislative Council the delays in the ordinary bill for up to the 4 months, it can't back and block it entirely. The final decision lies within the Assembly. The budget. The Legislative Council can discuss the budget but can't vote on the demand for the grant, which is the Assembly exclusively right. No confidence motion. The Legislative Council can't remove the Council of the Minister via no confidence motion. The ministers are only accountable to the Assembly. The rejection of the bill. If an ordinary bill originating the Legislative Council is rejected by the Assembly, the bill is considered dead. The presidential election. The the Legislative Council does not participate in the election of the President or Rajya Sabha representatives. The Constitutional Amendment. The Legislative Council has no significant role in the ratification of the Constitutional Amendment, with Assembly decision prevailing. The abolition of the Legislative Council. Legislative Council can be abolished if the Assembly recommendation it to be Parliament. The parliamentary privileges for the MLAs, some as MPs. The Constitution has also extended the privilege of the state legislature of those persons who are the entitled to speaker and take a part of the proceedings of the House of the state legislature or any of the committees. This includes Advocate General of the state and the state ministers. It must be clarified here that the privileges of the state legislature do not extend the governors who is also an integral part of the state legislature. Center-state relations, Part 11. First, the Constitution began federal in the structure, divides the all powers legislative, executive, and the financial between the center and state. However, there is no division of the judicial power as all the Constitution has the established and the integrated judicial system to enforce the both central laws as well as the state laws. Second, the center-state relation can be the study under the three heads. First, legislative relation. B, administrative relation. C, financial relation. Legislative relation, Article 245 to 255. The territorial extent of the central state legislation. Extent of legislation, Parliament, State. For whole or any part of India territory. The extraterritorial legislation, Parliament's law applicable to the Indian citizen and the property in the part of the world. State. The whole or any part of a state. State law can be the applicable outside the state is the sufficient nexus between state and objects is the established. Law of the Parliament are not applicable in the following areas. Presidential legislation for 5 UTs has some forces as a parliamentary law. Second, the governor empowered the direct debt and the act of the parliament does not applicable the scheduled area in a state or apply with the specific modification. Third, The governor of Assam may likewise the direct and the act of the parliament does not apply to the tribal area autonomous district in the state. 4. Residents enjoy the some powers with respect to the tribal area autonomous district in Meghalaya, Tripura and Mizoram. ATM without money. Distribution of the legislative subject Union list. The Union Parliament has the exclusive power to make the legislation on the matter of the include in the Union list 98 subject originally 97 subject state list. The state legislature have the exclusive power to make the legislation on the matters incorporated in the state list. The present 59 subject originally 66 subject concurrent list. Both center and state make law on the subject included in the concurrent list. The presented 52 subject originality 97 subject. Like the criminal law and procedure, civil procedure, marriage and the advisor, population control, and the family planning electrically, and the labor welfare, economic and the social planning, drugs and newspaper, books and the printing press and others. The Article 248, the residuary power of the gifts given the center and the Parliament of India also can be make legislation to the subject and not be included in any above the three list. 42nd Amendment Act of the 1976 that transferred the five subject to the concurrent list from state list. First, education. B. Forest. C. Weight and the measures. D. The protection of the wild animal and bird. E. The administrative subject constitution uh, organization of the all court except the Supreme Court and the High Court. The 101st Amendment Act of the 2016 has made the special provision with respect to the GST. The Parliament and the state have the power to make law with respect to the GST imposed by the union by a state. Further, the Parliament has exclusive power to make law laws for interstate trade commerce. The USA and Australia. A single enumeration. Only the power of the federal government and the enumerated in the constitution of the residuary power of the left of the state, the Canada, and double enumeration. The federal and the provincial, the presidency power are the vested in the center. Government of the India Act 1935. The threefold enumeration, federal, provincial, and the concurrent, the residuary power of the Governor General of India. In this respect, to the Indian follow the condition of the president. President. In the case of the conflict, in the case of the conflict between the central law and the state laws of the subject enumerated in the concurrent list, the central laws prevails over the state laws. But there is an exception. If the state law has been reserved for the consideration of the president and had received his asset, then the state law prevails in the state, but it would be still the component for the parliament to override such law by the subsequent making a law on the some matter. The parliamentary legislation in the state field. The Article 249. If the Rajya Sabha passes the resolution by the majority of the two-thirds of its members, the requesting the parliament to make law on the subject to the state list, the resolution remains the force for the 1 hour. It can be rewarded and any member of the times, but not the proceedings of the year at the time. The laws, the cases have the effect on the expiration of the 6 month after the resolution has been ceased to be in force. The Article 250. The Parliament to the make law on the any state list subject during the national emergency. However, the Parliament's law under the provision will be cases in the operate on the expiration of the 6 month or the emergency. Article 252. If two or more state legislature request to Union Parliament through the resolution to the make a law on the particular subject to introduce in the state list. Article 253. The Parliament to the make law for the whole or the any part of the Indian territory for implementing any treaty, an international agreement, the convention with the other country. The Article 356. During the proclamation of the President's rule in Indian state, the Union Parliament to the make the laws over the subject to the include in the sub state list. A law made so by the parliament the continues to the operative even the president's rule. This means that the prior for the such laws remains the force in not the contaminants with the duration of the president's rule. The center's control over the state legislation. Uh, um, Governor can reserve the certain types of the bills passed by the state legislature for the consideration of the president. The president enjoys the absolute veto over them. The bill on the certain matters enumerated in the state list can be introduced in the state legislature only with the previous section of the president. For example, the bills of the imposing the restriction on the freedom of the trade and the commerce. The center can be direct or state reserve the money bill and the other financial bill passed by the state legislature or the center's consideration during the financial emergency. The administrative relations article 256 to 263. The distribution of the executive power, union government. The executive power extend to the all subject on which the parliament can make law and to exercise the right to the authority and the jurisdiction confirmed on its by the any treaty or the agreement. For the concurrent list and the executive power is and with the state except when a constitutional provision or a parliamentary law specifically confirm if the one center. Therefore, a law of the concurrent subject through the enacted by the parliament is to executed by the state except when the constitution of the parliament has the direct authorized state government. The executive power shall be exercised in the conformity with the law made by the union parliament if such a mandates the not the compiled with the by a state and the state article 2 356 can be imposed. The center's direction to state article 256. The every state executive power is to be the exercised in the such manner as to ensure compliance with the laws made by the union parliament. Article 257. Executive power of the union shall be also extend to be the giving the direction to a state, the construction and the maintenance of the means of the communication declared to be of the nation or the military importance by the state. The measures to be the taken for the protection of the railways within the state. The relation during emergency, the national emergency. During the operation of the national emergency under Article 352, the center become the entitled to the give the executive direction to a state or any matter. The President's rule. The Union government can take the direct control over the machinery. The the President takes over the any state government's function. The Public Service Commission. The State Public Service Commission. The governor appoints the State Public Service Commission chairman and the member, but only the President has the authority to remove them. The Parliament can establish the joint State Public Service Commission for two or more. The state on the request to the state legislature concerned. The chairman and the member of the joint State Public Service Commission are the appointed by the Parliament. President. The UPSC can serve as the needs of the state to be request to the state governor and with the approval of the President. The UPSC assets at the state when and requested by two or more state in the framing and operating the scheme to join recruitments. All India services. All India services. Control of the center and state control. The center has the ultimate control over these services, whereas a state exercise the immediate and the relatively less control. The cooperation between the center and state. The parliament can provide the mechanism in interstate river water dispute. The president can establish under the Article 263 the interstate council to the investigate the discussion subject on the common interest between center and state. Such council was set up in the 1990. The full faith and the credit are to be given the throughout the territory of the India to the public acts, the records and the judicial proceedings of the center and the every state. The mutual delegation of the function. The president may, with the consent of the state government and interested state, and the executive function of the center. The governor may, with the consent of the center government, interested center any of the executive function of the state. The mutual delegation of the administrative function may be the condition or the unconditional. The entrustment of the executive function of the center to a state without the consent of the state, but this the case of the delegation is by the parliament and not by the president. Notably, the same thing the can't be the one by the state legislature. The appointment of the State Election Commission. The State Election Commission the appointed by the governor but the removed only by the president. The Financial Relation Article 268 to 293. The allocation of the taxing power. The Parliament and State Legislature. The Parliament and State Legislature have the exclusive power to the levy tax on the subject incorporated in the Union list and state list respectively. Union list 13 subject for tax, state list 18 subject for tax, and no tax entires in concurrent list. But the 101st Amendment Act of 2016 has made the exception by the making the special provision with respect to goods and services tax. This amendment has the confirmed the concurrent power upon the parliament and state legislature to make laws and the governing GST. The reservatory power of the taxation lies with the parliament only. Grant in aid. Article 275 first, the Parliament can issue the grant in aid of the revenue to such a state as the Parliament may the determines the different sums may be fixed for the different state. These sums charged on the Consolidated Fund of India every year. Article 282. The discretionary grants, both the center and state to make the grants for the public purpose every if it is not within the respective legislative concept competence competence under the provision the center to make the grant to the states goods and service taxes constitution 100 first constitutional amendment act 2016 article 279A empower the President to the constitute a GST Council by and the order of the Council is the joint force of the center and the state. The Finance Commission Article 280 it provides for the Finance Commission as the quasi-judicial body. Its other responsibility is the recommended the sharing of the taxes between them. Note: the income tax levied and the collected by the center, but the proceeds are the distribute between the center and state. Though the state legislature can impose tax on the consumption or sale of electricity, but no tax can be imposed on the consumption or sale of the electricity which is a the consumed by the center or the solid or center. B. The consumed by the construction, maintenance, or the operation of the railway by the center or by the concerned railway company or the sold the center or the railway company for some purposes. 3. The state legislature can impose the tax respect to the any water, electricity stored, generated, consumed, the distributed or the sold by the authority established by the parliament for a regulating or the developing any interstate river valley, but such laws and the effective should be the reserved for the president's consideration and the received his the asset. 4. The state legislature can impose the taxes on the profession trades callings and the employment, but the total amount of the such taxes payable by the person and should be not be exceed 2,500 per annum. The 5. The state legislature is prohibited for the imposing tax on the supply of the goods or services or the both in the following two cases. 6A. Where the such a supply tax applies outside the state. B. The state such applies the taxes place a concern of the importance and export. Further, the parliament is empowered the formulate the principles for the determining when the supply of the goods and services both tax and place outside the state or in the concern of the important the export. Distribution of the tax revenue. Article 268. Levy by center, collected by state, appropriated by state. Example: stamp duty and shares, checks, promissory notes and insurance, etc. Article 269. Levy by center, collected by center, appropriation by the state. Example: tax on the intense trade and commerce. Revenue from these do not for the part of the Consolidated Fund of India. Article 270. Levy by center, collected by center, shared between the center and state. Example: all taxes in union list income tax other than the agricultural income, corporate tax, etc. Article 271, levy by center, collected by center and centered. A surcharge tax under the 268, 269, 270 article. The state levy by state, levied by collected by center and used by the state. Sale tax, excise duty on the liquor and the narcotics, octorious professional tax, max up as a 2500, limited capped by. The protection of the state interest. To protect the interest of the state in the financial matter of the constitution lays down the following bills, and that can be introduced in the parliament only on the recommendation of the presidents. A bill which is imposed the various and be taxes a duty in which the state are the interested. A bill which the varies in the meaning of the expression and the agricultural income and defined for a purposes of the enactments relating to the Indian income tax. A bill which is affected by the principles which is the money, and the monies are be may be distributable the estate, and the bill which the imposed by the purposes or any specific tax or duty and purpose of the center, the borrowing by the center and the state. The central can borrow the either within the India or outside upon the security of the consolidated fund of India, or can give the guarantee, but but both within the limits of fixed by the parliament. So far on the such law has been the enacted by the parliament, the state can borrow within the Indian and not abroad. Upon this security of the consolidated fund of the state can be given the guarantee, but both the within the limits fixed by the legislature of the state. The central government can make the loans a loan to be any state, give the guarantees in respect to the loans raised by the state. Any summons required for a purposes of the making such a loans are to be charged on them the consolidated fund of India. The state can't be raised any loans without any consent of the center. If there is still outstanding any part of a loan made by the state by the center, or the respect to the which the guarantee has been the given by the center. The intergovernmental tax immunities. A. The property of the center is exempted from the all taxes imposed by the state or any authority within the state, like the municipalities, district boards, panchayats, and so on. But the parliament is empowered to the remove this ban, though the cor- corporation or the companies created by the central government or not the immune from state taxation or the local taxation. The reason is the corporation or the company is the separated legal entity. 3. The property of the income of the state is exempted from the central taxation. Such income may be the derived from the sovereign function or the commercial function, but the center can be taxed on the commercial operation of the state if the parliament provides. The remember made by the series of the parliament can be do not anything. 4. The property can income of the local authority situated within the state or not the exempted from the central taxation except the emergency. A. While the proclamation of the national emergency, Article 352 2 is a operation. The president can be modify the constitutional distribution of the revenue between the center and the state. Such a modification continues till the end of the financial year which the emergency cease the operates. Though, while the proclamation of the financial emergency, Article 360 in the operation, the center can give the direction to the state. A. The absorb the if specific canyons of the financial property. B. The reduce the salaries and allowance of the salaries of person and serving in the state, and to the reserve the all money bill and the other financial bill of the consideration of the president. Committee for the center and state relation by the state Rajamannar Committee TN Anandpura Sahib Resolution Akali Dal of the Punjab West Bengal Memorandum. In the 1983, the center government the appoint the three members the Sarkaria Commission. A. The permanent inter-state council called the Intergovernmental Council should be the set up under Article 263. Second, the institution of the All Indian Service should be further strengthened. Third, the residuary power of the taxation should be continued to remains within the parliament, while the other residuary power should be the placed in the concurrent. For the governor should be the eminent person from the outside the state and should be the debate figure without intents of the political links should be the not have taken in the politicals in the recent past. Note the interstate quantities is the union subject under the union list. Interstate relation. The interstate water disputes. The Article 262 adjudication of the interstate water dispute. The A. Parliament may be law to provide for the adjudication of the dispute or the complaint with respect to the use of the distribution of the control of the waters any interstate river and the river valley. A. Parliament may also provide that neither a Supreme Court or nor any other court is to be exercise jurisdiction in respect to the any such dispute and the complaint. B. The Parliament has enacted two laws. A. The River Board and Act that provide for the establishment of the River Board for the resolution and the development of the interstate river valley, a river board of the establishment by the central government on the request of the state governments concerned to the advice of them. The interstate water dispute can be empowered the central government to be set up and the ad hoc tribunal or the adjudication of the disputes between two or more states in relation of the water and the interstate river valley. The decision of the tribunal hold of final the binding on the parties on the dispute, either of the Supreme Court or not the any other court have jurisdiction in respect to the water dispute which may be referred in the such tribunal. Krishna dispute Tribunal 1 1969 the Karnataka Andhra Pradesh. The Godavari Dispute Tribunal 1969 Maharashtra Karnataka Andhra Pradesh Madhya Pradesh Odisha. Narmada Water Dispute Tribunal 1969 the Rajasthan Gujarat Madhya Pradesh Maharashtra. Ravi Byas Water Dispute Tribunal 1968 1986 Punjab Haryana Rajasthan. The Kaveri Water Dispute Tribunal 1990 Karnataka, Kerala, Tamil Nadu and Puducherry. Krishna Water Dispute Tribunal 2nd 2004, Maharashtra, Karnataka, Andhra Pradesh. uh, Vasundhara Water Dispute Tribunal 2010, Odisha, Andhra Pradesh. uh, Mahadai Water Dispute Tribunal 2010, Goa, Karnataka, Maharashtra. Mahanandi Water Dispute Tribunal 2018, Odisha and Chhattisgarh. Interstate Council. The Article 263 establishes of an interstate council. The council is a recommendatory body only. The president can establish such a council if at any times appear it him that the public interest would, would be served by the establishment. The Article 263 specifies the duties. Inquiry into the advising upon the dispute which may be arising between a state, the investigating and the discussing on the subject to which is the state or the center or the state have a common interest, and the making the recommendation upon the any such subject, and the particularly for the better coordination of the policy and the action of president has been established. Central Council of the Head or the Family Welfare, Central Council of the Local Government, on the recommendation of the Sakaria Commission of the Janata Dal government headed by the BP Singh, established by the Interstate Council in 1990. It consists of the following members: the Prime Minister as the chairman, a Chief Minister of the all states, Chief Minister of the Council Territory having the Legislative Assembly, the Administrator of the Union Territories not having the Legislative Assembly, the Governor of State under the President rule, a six Central Cabinet Minister including the some Minister to be nominated by the PM, the five Minister of the Cabinet rank Minister State Independent Charge nominated by the Chairman of the Council, Prime Minister, are the permanent investees council. The Public Act records and the judicial proceedings, Article 261. Under the Constitution, jurisdiction of the each state is confined to its own territory. Hence, it is the possible that act of the recorded of the state may not be recognized in the another state. To be removed the such difficulties, the Constitution contains the full faith and credit. Full faith and the credit are the given throughout the territory of the India is the Public Act record and the judicial proceedings of the center and every state. The expression of the Public Act include both legislative and the executive act. The manner in which that the condition under the which the such act records and the proceedings are to be the proved and their the effective determined will be as provided by the laws of the parliament. The final judgment and the order to the civil order and the court India is to be the executive anywhere within the India is the without the necessity of the fresh suit upon the judgment, and the rules of the applies only in the civil judgment and the not to be criminal judgment. Interstate trade and the commerce, the article 301 to 307 in the part 13 of the Constitution deals with the trade, commerce, and the intercourse within the territory of India. The one Article 301 declares that trade, commerce, and the intercourse of throughout the territory of the India shall be free. A parliament can impose the restriction on the freedom of trade, commerce, and intercourse between the states within the state and the public interest, but the parliament can't be give the profession to be one state over the another, discriminate between the state and the except in the case of security of the goods and any other part of India. the legislature of the state and impose the reasonable restriction on the freedom of trade, the commerce and the intercourse with the state or within the state public interest, but a bill for this purpose can be the introduced in the legislative only with the revise the sanction of the president. Further, the state legislature can't give the preferences to be one state over another or the discretionary between the state. The legislature of the state can impose the goods and importance of the other state or the union territories and the tax which is similar goods and manufactured in the state or the subject. The Parliament can appoint the appropriate authority and the carrying out the purposes of the above provisions, the relating to the freedom of trade, commerce, and the intercourse and the restriction on it. The Parliament can also confirm that the authority of necessary power and duties, but no such authority has been the appointed so far. The Zonal Council. The Zonal Council are the statutory remembered in the question if given as the constitutional be the careful it will be the wrong. Uh, they are established by the Act of the Parliament that is the State Re- Reorganization Act 1956. The Act divided and the country into the five zones: north, central, eastern, western, and southern, and the provided a zonal council of for each state membership. Each zonal council has set up a standing committee consisting of the chief secretary of the member state of their respective zonal council, the chairman, the union home minister of the chairman of the each of these council, the vice chairman, the chief ministers of the state included in each zone act as the vice chairman of the zonal council for the zone by the rotation, each holding the office for the period of 1 year at a time. The member of chief minister and the two other minister as the nominated by the governor from the each of the state and the two members from the union territories included in the zone. The advisor, one person nominated by the planning commission for the each of the zonal council, chief secretaries and the another office development commissioners and nominated by the each of the state included in the zone. The zonal council provides the excellent forum. There is a where irritant between the center and state the amongst the state can be resolved through the free and the frank discussion and the consultation begin. The advisory body there is a full scope of the free frank the exchange of the view and their meetings. The North External Council was created by the separate act of the Parliament, the North Eastern Council Act of the 1971. It's the member of the included Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, and Tripura and Sikkim. The member of the EC consists of the governor and the chief minister of the eight member, the state including Sikkim apart from the chairman and the three members who are the nominated by the President of India. If there is a no council of the minister in the any above the state, then the president may nominate not more than one person or two the represent such a state and council. The president is deemed to be necessary nominates the union minister to be a member of the council. The president shall nominate the chairman and the council. The president may the deems to be necessary to be so nominated another member of the council to act as a vice of the chairman and the council. So home minister may not be member of the Council name, the member and headquarters. The North Zonal Council, the Himachal Pradesh, Haryana, Punjab, Rajasthan, Delhi, Chandigarh, Jammu and Kashmir and Ladakh, headquarter New Delhi. The Central Zonal Council, Uttar Pradesh, Uttarakhand, Chhattisgarh and Madhya Pradesh, headquarter Allahabad. Eastern Zonal Council, Bihar, Jharkhand, West Bengal and Kolkata, headquarter Odisha. West Zonal Council, Gujarat, Maharashtra, Goa, Dadar, Nagar Haveli and Daman and Diu, headquarter Mumbai. Southern Zonal Council, Andhra Pradesh, Telangana, Karnataka, Tamil Nadu, Kerala and Puducherry, headquarter Chennai. Thank you for watching.